everyone, and thank you for joining us today. My name is Ruth, and I'm a senior associate specializing in UK immigration law. I will be leading today's discussion, focusing on policy direction and strategic implications of the recent immigration changes.
And I'm Monica, a trainee solicitor specializing in immigration. I'll be supporting Ruth today by talking through the practical and operational impacts these changes are having on employers.
As we moved through 2025 into 2026, immigration compliance has become a very broad level issue. These are no longer changes that sit neatly within HR or mobility teams. They affect workforce planning, cost focusing, and risk management across the businesses.
What we're seeing from the government is a consistent direction of travel, wider coverage of right to work obligations, higher financial penalties and sponsorship costs, and significantly reduced flexibility within the immigration system.
By the end of today's session, our aim is that you leave with a clear understanding of where these risks are and what the immediate actions you should be considering now to mitigate those risks.
The following slides showcase a timeline of UK immigration changes starting from May 2025, and they will help illustrate not only what has changed, but how quickly and deliberately those changes have been introduced. Starting from the 12th of May 2025, the government published a white paper setting out its strategic approach to reducing net migration. This did not introduce immediate legal changes, but it was a foundational moment in policy terms. The white paper established a clear direction of travel, linking migration more closely to contribution, skills, compliance, and integration. It also signaled that substantial reforms would follow across work, study, and settlement routes. That policy direction began to translate into legal reform on the 1st of July 2025, when the first statement of changes to the immigration rule was laid before Parliament. These changes were focused largely on skilled worker route, making it clear that work migration was an early priority. For employers and sponsors, this was the first detailed indication of how white paper commitments would be reflected in the immigration rules. Those changes then came into force on the 22nd July 2025. From this date, the revised skilled worker requirements applied to new applications and certain in-country changes. The changes tightened eligibility under the skilled worker route, including more restrictive assessments of whether roles genuinely met the required skill level, greater scrutiny of job descriptions and working arrangements, and most of all, reduced flexibility around sponsorship structures. Salary assessments also were more closely aligned to the role actually being performed, increasing the risk of refusal where roles, salaries, or duties did not fully meet the revised requirements. The short lead-in time reinforced the need for employers to stay ahead of immigration developments. On the 29th September 2025, the government published a news update outlining potential criteria for a contribution-based earned settlement model. While this did not amend the immigration rules, it was a significant policy step. It introduced the concept that settlement may increasingly depend on factors such as economic contribution, skills, salary progression, and long-term compliance, rather than simply the time spent in the UK as it's been so far. The next major milestone came on the 14th of October 2025, when a second statement of changes to the immigration rules was published. This confirmed a further tranche of white paper measures and provided clarity on additional reforms scheduled to take effect at a later date. From the 8th of January 2026, the higher English language threshold applies to new applications under specific work routes, including the skilled worker route. At this stage, the higher requirement does not apply to extensions or settlement applications, although this might change in the future phases of the reform. For employers, the immediate impact is therefore focused on new hires rather than existing sponsored population. However, it is widely expected that English language requirements will continue to tighten over time, particularly in the context of earned settlement reforms. As a result, employers may still wish to factor this into longer term workforce planning and support strategies, even though it is not yet a requirement for extensions or settlement. Parliamentary scrutiny intensified shortly afterwards. On the 21st October 2025, the House of Commons Home Affairs Committee opened a public inquiry into the earned settlement proposals with a deadline for written evidence of the 2nd of December 2025. This provided an important opportunity for employers and stakeholders to influence how the earned settlement model may be shaped before it's finalized. Then, throughout November 2025, a further tranche of the white paper reforms came into force in stages on the 4th, 11th, and 25th of November. These changes were deliberately staggered due to their breadth and impact across multiple routes. One key change was the expansion and formal capping of the high potential individual route, while the pool of eligible candidates was broadened in some respects. The introduction of a numerical cap limited overall access to the route. This increased competition and reduced certainty for employers using this route as an alternative to sponsorship. The November changes also included revised grounds for refusal across work and study routes. This expanded the Home Office discretion to refuse application based on credibility concern, prior immigration history, and compliance issues, placing greater importance on clean immigration records and consistent sponsor compliance. In addition to this, student visa conditions were tightened. These changes included restriction on course switching, closer monitoring of compliance, and changes to work permissions for certain courts. Although targeted at students, these reforms have knocked on effects for employers who recruit graduates or rely on the graduate route as part of the workforce planning. Alongside these migration and settlement reforms, there has been a parallel and increasing focus on the right to work compliance and preventing illegal working. Going back on the 7th of May 2025, an illegal working clause was added to the Border Security, Asylum and Immigration Bill. This signaled that the government's intention to strengthen enforcement powers and place greater responsibility on employers to prevent illegal working across all labor models. The amendments, the clause extend the duty to conduct right to work checks beyond traditional employees to include workers, self employed contractors, agency workers, and individuals engaged through online matching platforms. Further detail emerged on 31st October 2025 when the government opened a consultation on extending the right to work scheme with responses invited until the 10th of December 2025. This consultation explores expanding right to work checks to non employee workers, contractor, and platform based labor, reflecting the increased emphasis on compliance and enforcement. On the 2nd of December 2025, the Border Security, Asylum and Immigration Act 2025 received royal assent. This marked a significant legislative milestone, providing the statutory framework needed to support tougher border security measures and strengthen the legal working regime. And now, looking ahead to 2026, the expanded illegal working regime is expected to be operationalized. While precise implementation dates are still to be confirmed, employers should expect practical changes to compliance, obligations, and enforcement activities. These changes, combined with higher English language requirements from the 8th of January 2026, underline the need for early preparation rather than reactive compliance. Taken together, this timeline shows a clear progression from high-level policy intent through to immigration rule changes, legislative reform, consultation, and parliamentary scrutiny. It underscores the pace and scale of change across the UK immigration system and why proactive planning is now essential for employers.
Now, Ruth will talk about expansion of right to work obligations and what's changing.
Thank you so much for that. One of the most significant developments is the expansion of the right to work obligations beyond the traditional definition of an employee as defined by the Employment Rights Act. The government plans to extend these checks to non-employment workers, including self-employed contractors and individuals engaged through online job matching and labor platforms.
This reflects a deliberate effort to close historic loopholes that were based on employment status. The Home Office is increasingly focused on the reality of working arrangements rather than how those arrangements are labeled contractually.
But why does this matter? For employers, this means that relying on the label or the term contractor will no longer be enough to avoid right to work responsibilities. If someone is providing labor that benefits your organization or your business, you must have compliance obligations.
We're also seeing increased enforcement activity in sectors that rely on gig economy and flexible labor models, such as hospitality or constructions company. This brings greater civil exposure and, in some cases, criminal risk, particularly where responsibility are unclear or assumed to sit elsewhere.
The next slide addresses how this impacts employers. A key challenge will be establishing who is responsible for carrying out right to work checks, what evidence needs to be collected, and how long it must be retained. These standards are not being relaxed by the Home Office, they're simply being expanded.
There are also contractual implications. Employer will need to revisit the arrangements with agencies and platforms because while checks can be delegated, liability often cannot. Non-compliance can result in civil penalties and serious sponsor license consequences.
We have recently seen an increase in right to work notices from the Home Office. Right to work compliance is often the first area the Home Office examines. Right to work failures are a common trigger for investigation and can quickly escalate into sponsor license downgrades or even suspensions.
Penalty for illegal working are also increasing in scale and frequency. The Home Office expects employers to demonstrate proactive compliance, not just reactive problem solving.
Monica, those were really valid points. Now we're going to address the common mistakes employers make. In our line of work, most failures that we see are not deliberate. They tend to involve incorrect expired checks, inconsistencies processes across the teams, or even uncertainty about who conducts compliance internally within organizations and businesses.
There is also often over-reliance on third parties combined with weak audit trails. It's important to remember that outsourcing a process does not outsource liability. Therefore, we always advise our clients to conduct periodic audits.
We have to address audits, and it's very important that we start acting now. Periodic right to work audits allow employers to identify historical risk before enforcement action occurs and to evidence a genuine culture of compliance, which will be beneficial to the organization.
Best practice includes centralized ownership of right to work processes, regular internal audits, and training that extends beyond HR to line managers and procurement teams, especially where contractors are engaged.
This slide addresses the immigration skills charge. Turning to sponsorship costs, The immigration skills charge increased by 32%, which was effective from the 16th of December 2025. This applies per sponsored worker per year and represents a significant uplift.
For employers with large sponsored populations or long sponsorship periods, this will materially increase the overall immigration spend and place further pressure on recruitment budgets. This is the point at which employers should be reviewing sponsorship models, considering role duration, exploring alternatives to sponsorship, and factoring immigration costs into workforce planning much earlier.
In our previous webinar in July 2025, we addressed the minimum salary threshold and how that was going to impact a lot of sponsored workers. We have seen changes to how minimum salary threshold for skilled workers are assessed. Thresholds are higher, the assessment rules are now tighter, and there's much less flexibility around the allowances that you can use.
This creates risk for existing sponsored workers, particularly at extension, change of role, or settlement stage. We're also seeing retrospective salary scrutiny during home office audits. Employers should now be reviewing their sponsored populations, aligning pay review cycles with immigration requirements, and identifying at-risk roles early.
There has been a lot of noise recently in immigration, especially around the earned settlement policy. This slide addresses what we need to know and what worries employers, so it's generally an overview of the earned settlement model. The earned settlement policy is one of the most significant proposed changes in recent years, and I stress the word proposed because it's just a proposal at this change. The proposal is to move away from settlement being time served towards settlement being something that must be earned. The focus is on economic contribution, compliance history, and salary progression, which places much greater importance on long-term planning and ongoing compliance. The next slide explains how the Home Office intends to calculate indefinite leave to remain in the future based on the earned settlement proposal. It's not just about waiting for the 10 years instead of the 5 years. It's about a point-based timeline where your salary, job, past decisions literally add or subtract years from the path to indefinite leave to remain. We have broken down the tables that have been provided by the consultation, which is table 2 and table 3, and will provide real life examples of how this is going to work. As we can see from table 2, the Home Office are intending to cut the waiting time in some scenarios for people who meet the threshold that they are providing, essentially based on earnings. And this reduction will be explained in the slides coming. Someone who is earning over £125,000 a year for 3 years can apply for settlement within 3 years instead of the 10 years. This would be of great benefit for people that are on a higher earning threshold. The other proposal that they're having is if someone is earning £50,270 a year consecutively for 3 years, they can settle in the UK for 5 years, not the 10 years as previously indicated in the proposal. Workers such as teachers, NHS professions who've been working for 5 years can also settle in the UK for 5 years and not the 10 years. Volunteering in the community as well has of great benefit and would contribute to some people settling earlier. So this is about not just contributing economically as well, but essentially integrating into the society. One of the key factors that they were also indicated, which would also reduce in a reduction, is English language, which
technically is something that is actually a requirement when you're applying for indefinite leave to remain for people that are not exempt. You would need to pass an English language requirement. What the Home Office is proposing is one has to pass English language at C1 level, and this would reduce the settlement by 1 year. The next slide provides real life examples on how this is actually going to work on paper. So, the first exemption that we explored is people that are earning £125,000 or more per year consecutively for 3 years before the application. In this scenario, we have Raj, who is a software engineer in London. He earns £130,000 a year. After 3 years of earning this salary, he can technically apply for indefinite leave to remain, which would be of great benefit rather than waiting for a qualifying period of the 5 years, which is provided by Appendix Skilled Worker or Appendix GBM. The next example we have is Priya. Priya is working as a senior nurse in the NHS, and she's earning £52,000 a year. After 3 years of this salary, she can apply for indefinite leave to remain, which is exactly the same provisions that are provided by Appendix Skilled Worker if she's on a skilled worker visa. Then we have Ahmed. Ahmed is working as a teacher in a state school, which is essentially a role which is an RQF 6 role. Ahmed has been a teacher for 5 years. What the new guidance is providing, or the new proposal rather is providing, is Ahmed can apply for indefinite leave to remain after 5 years. Then we have Maria, who volunteers at a local food bank, and she's been doing this for 5 years. She can get a further reduction based on this. Essentially, what we're realizing from this proposal is the Home Office are trying by all means to assess how people are contributing economically and integrating into society, which would further increase the possibilities of reducing the qualifying period of indefinite leave to remain from the 10 years to slightly less. Table 3 explains how the waiting time for indefinite leave to remain would essentially be increased. This does not technically affect the majority of the clients that we deal with, but essentially, people who claim welfare benefits for less than 12 months will have the waiting period increased to 15 years and would not qualify after 10 years. People that have also arrived illegally or switched from a visitor's visa or overstayed will also be facing penalties and would potentially have the baseline for the application for indefinite leave to remain increased to 30 years. So it's essential that we're advising our clients not to be claiming benefits during the period so they are not affected by this new proposal. What we have also realized is it's not everyone. The proposals are not going to affect the majority of people. So spouses of British citizens will still qualify after 5 years. This does not remain changed. Hong Kong visa holders, so these are Hong Kong British national overseas holders, would not be affected. They're still within the 5 year path. The global talent and innovator founder visas as well have not been affected. This would essentially lead to qualification after 3 years or the 5 years. What does this mean? What do the new proposals mean for the future? If you're earning higher salaries, volunteering, you can reduce your wait time. If you've claimed benefits or overstayed, you can face serious penalties. As previously indicated, the timelines would be increased. Care workers, middle skilled workers would face 15 years as well. Everyone currently in the UK who hasn't got ILR would be essentially affected by these proposals. We do not know how the consultation is going to end in February, and we will definitely be advising you if there are any significant changes that have been enforced, or if the Home Office have accepted that this should be enforced as law. But for the time being, what we're essentially advising our clients is these are just proposals. And right now we need to be working extremely hard to see how best we can caveat any future reductions.
The most common concerns that we're hearing is around the transitional arrangements, particularly how these changes will affect people already in the system. There's also concerns that settlement timelines might lengthen, creating uncertainty for both employers and sponsored workers who are trying to plan for their future.
For employers, this creates real retention risks and workforce planning challenges. It may also mean longer sponsorship periods, higher cumulative costs, and increased scrutiny of sponsor compliance history. Stable employment, salary progression, and strong compliance record are likely to become increasingly important. Employers should be thinking now about how they communicate with sponsored workers, support them through uncertainty, and plan for longer-term sponsorship where necessary.
So what are the key takeaways from our webinar and what are the immediate actions that you need to think about? To summarize, employers should be expanding the right to work beyond employees. As we clearly indicated, the changes that are coming in force with the Borders Act 2025, considering proactive compliance audits, reassessing sponsorship costs, and this is in line with the increase of the immigration skills charge, and identifying workers who are at risk under the earned settlement framework, which at this stage we indicated is just a proposal.
The key message is that compliance failures are becoming more expensive and more disruptive to fix after the event. Early, proactive action is almost always cheaper and less damaging than enforcement. The government is consulting on how the current settlement system should be reformed and how those reforms should be implemented. This consultation is currently ongoing and it closes at 11:59 p.m. on the 12th of February 2026.
These are the broad changes that we've seen developing through 2025 into 2026, and we'll keep you posted with further webinars and via our website and LinkedIn.
However, please do get in touch with us now and start planning ahead. Thank you very much for joining us today and we hope to see you soon.
Thank you so much. We really appreciate your time.